Record this matters before the court on the plaintiff's mother's motion to modify custody, parenting time, and child support. The parties have conferred this morning with the front of the court. The court has received the following recommendation this morning from Mr. Walker. The recommendation is that with respect to parenting time, all parenting time exchanges shall be at 6 p.m. The party whose parenting time is starting shall be responsible for transportation. The parties shall use app close for all communication if either party requests to use the application in writing. It's also noted that defendant owes $4,796 in past due child support. He shall pay $218 per month commencing October 2024 directly to the plaintiff. The payment of $218 shall be due on before the last day of each month until the arrears are paid in full. It's not inconsistent with this order shall remain in full force and effect. That is the recommendation. Ms. Patillo, is this recommendation good with your client this morning?
It is, Your Honor. The only thing that's not good with my client is she's going to lose her child care because defendant father has abruptly moved the child to a different school setting. So that's the only issue that's kind of left. Okay. But other than that, we do agree with the referee's recommendation outside of the school.
Okay, did you discuss during mediation the issue of the daycare?
We did, but because the child is not actually school age yet, it's not going to be decided. But the child has been at Solt Elementary since she was 8 to 10 weeks old. That's the only school, daycare, preschool that she's attended. So this year, Dad decided he wanted the child to go to another daycare a couple of days throughout the week. But because of the parenting time schedule, my client is going to lose her child care because the child can't go part-time. So my client really would like if the, I don't know if the court would, but we're asking if the court would, allow the child to remain at Solt Elementary and that the school be determined next fall. Because she's just being bounced around. It's not fair to the child, one. And then, like I said before, mom is going to lose her child care. The child can't go part-time.
So mother will lose, is she paid in advance or she lose money, or she simply will lose her spot in the daycare because they will not take, they want full-time child care?
Yes.
Child cannot attend mom's daycare 2 days a week. They want the child to be there 5 days a week?
Yes. The child has been there since she was 8 to 10 weeks old. She's 4 years old now. So there's really no reason for her to be moved.
Well, why won't the daycare allow, you think that they would allow a child to be there for what mom's got, right now, parenting time is 2 days on, 2 days off. Why can't on mom's days, the child go to mom's child care? You're saying child care will not allow that?
My client can speak more if the court would allow, but yes, she was told that they're waiting on the court to make a decision, but other than that, she's going to lose her child care.
So perhaps, so they would obviously permit that if the court ordered, mom could use her daycare on her days and dad can use his daycare on his days. Is there any problem with that, Ms. Patillo or Ms. Colviak?
Yes, the school is actually, because the child has to go the whole week, they're waiting to see if the court makes a decision as to the child remaining at Solt Elementary the whole week, as opposed to her going to Riverside, where dad has put the child just in here.
But what if the court decides that the child goes to mom's daycare in her days and dad's daycare in his days? Would they accept that?
Ms. Jackson, I don't think so. Ms. Jackson, can you, if the court would allow Ms. Jackson to?
I've already.
Do we need to have a hearing on this issue? Again, I'd rather hear from the attorneys this morning. So obviously you're saying no, that they will not allow that. Even if you suggest if the court ordered, they're waiting for the court's order. So if the court ordered that, would they permit that? And she's shaking her head no. I mean, she should at least inquire.
I'm sorry, Judge. They're waiting for the court to order that the child remain at Solt Elementary.
Okay. Well, how about if the court orders that the child remain at Solt Elementary on mom's days and mom's days? And that's the court's, what's wrong with that order?
Because the child can't attend Solt Elementary part-time. She has to go full-time. Or
even if a court ordered that, is that your understanding?
Yes.
Okay, and this child's been in Riverside since when? Since September?
Yeah, Sold Elementary from 8 to 10 weeks old, and Riverside, I believe she just started.
Okay,
So, Your Honor, if you'll recall, this has been an ongoing issue from the time that we first started this case, because that was a decision that mom made for the child to go there. We have objected and asked for the child to go elsewhere. And last spring, we had a motion regarding preschool because we wanted the child to go to Monroe preschool. And at that point, the court decided exactly as you just said, which is preschool is not mandatory, and therefore dad can send the child where he wants on dad's days, and mom can send the child where she wants on mom's days. And therefore, my client did exactly what the court ordered. And the court specifically has an order which indicates that it's not going to make a decision regarding school until the child is 5 years old. So we would have already had a hearing on this, but that has been the decision, and that is what the parties have complied with. And it's our position that, I mean, I suppose we can have a hearing at some point. I'm sure that this is an issue that we're going to have a hearing about. The question is, when is that going to be, whether it's going to be kindergarten, as the court previously said, or whether we're going to have it regarding preschool, which is not required.
what was the date of that order that you're referring to, Ms. Colviak?
And Judge, if I may, I think the main issue here is that, again, my client would lose her child care, but the child has been in one school, preschool, daycare, since she was 8 to 10 weeks old. Even though there may be an order, I was retained May of 2024. Even if there is an order that allows both parents to send the child to whatever daycare they choose, that just happened this year. The child has always gone to Sold Elementary. So there was no reason to move her out of the elementary school that she's been going to for daycare and preschool for the last 4 years. There was no reason to move her.
Okay, obviously they move, I do see the order here.
May
The order of
22nd.
May 22nd, 2024. Issue of minor children school district is reserved till the child attains the age of 5 years old. The court did not address daycare. So the opinion of this court is that dad's responsibility for daycare on his days and mom's on her days. So maybe mom can find a different daycare. So do we need to add that to this order? And maybe with that, Miss Jackson can get her the minor child, Madeline, back into the Sold Elementary preschool. It sounds like mom wants to do what's convenient for her, dad wants to do what's convenient for him, rather than what's the best for the child.
Well, mom wants what's best for the child instead of moving her to a totally new school at 4 years old.
No, we disagree. We believe that what's best for the child is for the child to go to Monroe, and we've wanted her to do that for a while. We've had this dispute ongoing for quite some period of time. There's nobody lives in Jefferson School District.
My client does.
She does not live in Jefferson School District.
Yes, well, I spoke to my client. Yes, she does. Miss Jackson, we discussed you living in Jefferson School District, right?
Yes, I
You
know.
live right behind Sold Elementary, correct?
Correct.
Right, so she is in the district.
When does the child attain the age of 5? This summer?
June 2025, she'll be 5.
Do
So
you want
we'll
to schedule
still-
mediation? Because
parties
it
will
sounds like
be-
the court's gonna have an evidence hearing sometime in the spring. Do you want us to try to work through these issues, or the parties want the strangers to make these decisions?
We can try mediation.
Well, the court would suggest that before someone requests an evidentiary hearing, whether we should do that in the spring rather than wait till the fall when everyone wants to address school changes. So if the parties cannot agree, then someone should make the request for an evidence hearing sometime early in the summer or in the spring. In the meantime, the court suggests that the parties mediate with Mr. Walker or someone from the front of the court regarding the school issue. But at this point in time, the court's going to simply order that on dad's parenting time, it's his responsibility to provide for daycare costs and everything, and then mom's the days she provides for daycare. And they can choose where they want to take the child.
Your Honor, can I ask a question? When we get to late spring, early summer. Would it be acceptable for either Ms. Patillo or myself simply to schedule with friend of the court without filing a motion?
Absolutely. You can reach
Okay.
out to the front of the court. That's what the court would suggest is when you reach out and then spring to the front of the court, whether it's Mr. Walker, Mr. Pratt, Ms. Patrick, Ms. Brower, to schedule mediation with them. And then you can zoom into the court at the same time after mediation. And at that time, either put agreement on record or request an evidentiary hearing. That's what the court would suggest. So absolutely, Mrs. Colviak.
Okay, thank you.
So the court's going to modify its recommendation. Dad shall address the response for daycare and his time, mom on her time. And the court shall app close for all communication, period. We're not going to have it be the party requested application, right? If these parties cannot agree upon these things, the court's going to make these decisions. So all communication shall be via app close. We're not going to argue about it. Someone's requesting it in writing. So Mr. Walker, good morning. If you can just indicate the parties shall use app close for all communication and only regarding the minor child, modify that sentence. With respect to the other issues, Ms. Patillo, obviously your motion to modify custody parenting time and child support, the court does not find that there's a sufficient change in circumstances to modify custody or parenting time. It's alleged that the plaintiff was bullied into this agreement. She had legal counsel. And the court's been, all we need to do is address perhaps a more specific parenting time schedule. So it sounds like we have an issue. They got 2 days on, 2 days off. We need to modify the parenting time schedule. That's the only thing before that this court believes may be necessary. Do we need to fine tune this parenting time schedule?
We discussed that issue and the parties decided they wanted it to stay the same, Your Honor.
Right. Anything else, Ms. Patillo, you want to add on your motion to modify custody or parenting time?
No, Your Honor.
Right. Ms. Walker, if you can also add the recommendation of the court to deny the plaintiff's motion to modify custody or parenting time. Is there current child support being paid?
No,
Okay, so this simply are arrears.
correct.
Is this amount satisfactory, Ms. Patillo, in terms of $218 a month?
Yes, Ms. Jackson agrees with that amount.
All right, so Mr. Solomon, you got him pay $218. You got 1 week to pay that.
Understood.
These are minimum payments. Let's get this done. I mean, let's not drag us out over the next 10 years. Let's get this done.
Understood.
Why can't you pay more than $218 a month? Why can't you pay $300? $300 is much easier to modify. So the courts can already pay $300 a month, right? We can modify Mr. Walker. Mr. Solomon should pay $300 a month commencing October 2024 and $300 the last every month thereafter until the arrears are paid in full. Anything else further this morning, Ms. Patillo or Ms. Colviak?
No, Your Honor.
Mr. Walker, do we have to capture those modifications?
Your Honor, do you also want me to add the verbiage regarding the daycare? Each party is responsible for their own daycare.
Please, yes. Each party is responsible for daycare, location, and expenses on their parenting time. All the communication shall be by app close. Mr. Solomon should pay $300 a month for the arrearages beginning in the month of October 2024. And finally, that the plaintiff's motion to modify custody and parenting time is denied. Insufficient change, there's not a sufficient change in circumstances to do so. Okay, the court modified that, and that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.